Aloha, everybody, and welcome to this episode of the Triple F podcast, Faith and Family First, where Jim Hochberg and myself are going to be interviewing my counterpart from Tennessee about maybe some similarities between Tennessee and Hawaii. Maybe not, but you'll have to stay tuned to find out. Welcome to the show, Mr. Hochberg.
Well, thank you, Eva. Same to you.
It's always good to sit across the table from you.
Okay.
And I think I like getting all the emails from the Team Eva or the Team Jim, but that's okay because people.
I don't have a team.
You have a team. You have a Team Jesus. We're all on the same team.
Okay.
Okay. And we're willing to welcome my counterpart from across the seas, David Fowler from Tennessee. Welcome to the show today, David.
Well, it's so nice to be with y'all from Tennessee.
Do you want me to turn on I can turn on a little bit of that too, because my mama's from the South. So, we
I
could.
don't know that.
Well,
Yeah.
she's from Missouri. I don't know. Do you consider Missouri from the South?
Below the Mason-Dixon line.
Is that
Below
how
the-
that runs?
Yeah. So that's good enough for me.
Okay.
But no, I'm sorry. I was laying that on thick.
Do you know
So-
Billy Ray Cyrus?
Oh, what do you think that he knows everybody with a Southern accent?
I do not know Billy Ray Cyrus, but 20 years ago, maybe, I was in the local Target and Miley Cyrus was in there with a high school friend changing clothes while my daughter was changing clothes. Now, this is before Target went woke. And some little girl was out there, just couldn't die. I was just dying to get Miley's autograph. And I thought, that's got to be tough that you can't even go try on clothes at the local Target without somebody finding out you're in the.
And fast forward to today, and who knows who might be trying to get into that
Anyway,
dressing room.
Miley came out and I said, I'm a former state senator. Would you like my autograph? And she didn't.
Yeah.
That's
Yep.
what I love about you, David. I just love David. Okay, so let's bring everybody up to speed. So I kind of opened saying, what does Tennessee and Hawaii have in common? It really has nothing in common except that Hawaii Family Forum signed an amicus brief that you put together. But before we get into the amicus brief, I think you should kind of let everybody know about the Tennessee law that created the need for the amicus. So maybe you can bring everybody up to speed.
Sure. It's similar to laws that other states have passed. I think now 17 or 18 have passed them that in one way or another are trying to prevent doctors and healthcare facilities providers from providing gender affirming care in the sense of changing their hormone development with puberty blockers and surgical procedures. So I guess for the purposes of our discussion, we probably should talk about transgender medicine because this isn't counseling that anybody's talking about. It's applying medical science to alter the human body's normal development. So transgender medicine, I guess, is what I call it. And in Tennessee, we did something that I think is a bit different in that rather than just flat prohibit the procedure or make it a crime like we so often did with abortion over the years, the statute here said that any person who has transgender medicine applied to them may sue for damages for up to 30 years after they reach the age of majority. So if a 15-year-old woman has her breast buds removed and at the age of 32 realizes that was a hoax, it was a bad idea, I can now never lactate, I may not even be able to have children, she could go back and sue the doctors for her damages. Now, in addition to that, if the doctor were to provide that procedure, there would be a report made and the doctor would come under licensing procedures and could lose his license. But we didn't make it a crime because that creates automatic standing for the moment it becomes law and there's a crime. Technically, there's no, and Jim may disagree, but I think their thought was paralleling the Texas law on abortion that said, well, if you're damaged by an abortion, you can sue. Well, until somebody sues, you don't know what's going to happen or if anybody will be injured. Nobody may ever sue. So that's how Tennessee did it. But they're all trying to do essentially the same kind of thing, is prevent doctors and providers from using their transgendered wizardry skills to alter human life.
So let me, for our viewers, explain what our legislature did this year.
Oh, yes.
So our legislature passed a law saying it was expressly in response to that Texas abortion law.
Okay.
Our judicial system and the state government will not participate in any discovery or court order enforcement against an abortion provider in Hawaii, where the case on the mainland is seeking damages against the abortion provider. So what our legislature did is said, we're going back to the Articles of Confederation on the abortion issue, and we're not honoring your full faith and credit of your Texas court orders, judgments, subpoenas, discovery requests on doctors and abortion providers that are in Hawaii. So if somebody from Texas comes here, gets an abortion, goes back home, and somebody else in Texas is able to bring a claim about that abortion, Hawaii is not living up to its constitutional obligation for that family in Texas.
Because that's how we roll here in Hawaii.
They
David
also
Fowler.
proposed a constitutional amendment, which hasn't passed out of the legislature yet, but it can again next year, making it a constitutional right to reproductive freedom, including all the gender stuff.
Yep.
Now, Jim, you kept using the word abortion, so I assume you were doing that intentionally, not referring to transgender procedures, right?
Correct.
Because I was
the Texas abortion law. Yes.
Okay. So y'all haven't passed a transgender prohibition law. I assume you probably couldn't.
No, we wouldn't be able to do it. In fact,
No,
they would probably do for the transgender what they did for the abortion. So, protect the doctors at all costs.
Right. Okay. Well, I was trying to think here. Is the switch from transgender over to the abortion issue or what? So okay, I think I got what you did. Is essentially y'all said for abortion, we're not going to help anybody if you're over in Texas suing under the Texas law
or Tennessee.
Right. Yeah. Okay.
Yeah. But that doesn't mean that we can't try and do good things, which is why when you came up with this brief, why we wanted to be part of it.
So tell us about the lawsuit.
Well, this is a really, really scary lawsuit. Now, 2 laws were passed, and Eva, you'll have to help me remember. I think it was 1920. You remember when we were at that conference in 1920? Eva? It was right before Jim was born.
I do remember that, Jim. I don't know why. You wouldn't have enjoyed it anyway. We had fun.
Yeah, but
I couldn't get past Woodrow Wilson, and I wasn't here in 1920.
David had brought all this liquor with him that he had in his suitcase because it was during the Prohibition time, right? So
it was the Roaring '20s.
Yes.
We had a great. Anyway, I think it was in 2020 that Arkansas passed the first law trying to ban or prohibit or limit these transgender medicine applicable to minors. And it was immediately held unconstitutional. It was appealed to the Court of Appeals. And earlier this year, the Court of Appeals affirmed that the law in Arkansas was unconstitutional. And I don't know if Arkansas has appealed it or is trying to appeal it to the United States Supreme Court. But that's the last I knew on that one. Then Alabama passed one last year, and it was held unconstitutional with respect to the with respect to the surgical procedures. They said that that they were going to have a trial over the surgical aspect of the bill as opposed to the hormone treatment part. Now, they did have the trial back in, I want to say, March, maybe, something like that. And I don't think there's been a result there. But part of that law was also held unconstitutional. The part about the hormone treatments, that medical science says the hormone treatments are good and they're helpful, and parents should be able to go ahead and approve hormonal treatments for their child. So, and then last week, I think it was 2 weeks ago, Florida's law was held unconstitutional with respect to, at least again, the hormone treatments. Parents have the right to decide to authorize those for their children. I think the question of surgical procedures is still left open. So essentially, we're 0 for 3. And what happened in Tennessee is a bit unusual. Missouri, or Missouri, depending on how you pronounce it, did pass a law, and for whatever reason, the ACLU is not sued over there yet, to my knowledge. And the DOJ has been rumbling about it, and the DOJ's Department of Justice has been rumbling about the one in Alabama. But in Tennessee, they actually moved to intervene to file their own complaint, not just the complaint of parents and doctors, by the ACLU and Lambda Legal. This is now the United States Department of Justice. And their single claim is that the Tennessee law violates the Equal Protection Clause of the 14th Amendment. And the legal theory of the Department of Justice is frightening. When you read the elements of the complaint, and this is not just my opinion, but and not that I'll drag another person in, but Eva, I often work with another lawyer who used to practice out in Colorado and litigated for a large national Christian organization. And I talked to him, and he said, yeah, what the Department of Justice is saying is persons now need to be understood for constitutional purposes as their gender identity. So some of your listeners may remember years ago, there was homosexuality. Then there was, well, it's my sexual orientation. And then it became, well, everybody has a sexual orientation, right? Some are heterosexual orientation, some are homosexual orientation, some are bisexual orientations. Well, now the department is saying everybody has a gender identity.
And there's over 70 right now, right? I mean, I think that's the last I heard.
The department in this brief just simply categorizes them as transgender and non-transgender. Now, this is something I did not know till I read the complaint, and I called this friend of ours, Jeff, and I said, am I reading this right? And he said, yeah, you're reading it right. But I always thought the transgender person had gender dysphoria. That's why they were transgender. But no. A transgender person is one who subjectively, take me for example, I subjectively consider myself a girl. I want to be treated like a girl. I act like a girl. I have the rights to do all the things girls would have, but I'm comfortable being a girl in a male body. But some transgenders, the complaint says, have gender dysphoria, and they can't be comfortable. In other words, David is not comfortable being Darlene in a David body. So he has to have these therapies to create congruence where there's incongruence. So that was an interesting thing. So what the department is saying is now, instead of seeing people as bodies, embodying a truth, like we're male and female, we don't embody any reality. We are to be understood according to our gender identity.
Can I ask you a question?
Yeah.
Under that understanding, which of the two transgender groups get the hormone treatments in the medical service? The one that has dysphoria or the one that's comfortable with it?
Just the dysphoria ones.
Interesting.
So again, take me. I think I'm Darlene, and I want to swim on the girls' swim team, go to the girls' locker room, go to the women's poker game, whatever it is. And I'm perfectly comfortable with all my stuff.
So what happens when the other girls in the room aren't comfortable with you there?
Well, I think we saw that with the Leah Ham situation in the swimming pool, where he was just changing clothes with the rest of the girls, right?
Well, what I was getting at is the comfortableness of the transgender person without dysphoria. Do they then become dysphoric because now they're uncomfortable with the response?
No, not necessarily. I think what they're doing is they're saying, well, everybody's got to get over it. That's what the swimmers were told.
This is really weird.
And,
This is very
and
weird.
they have to go to counseling. See, what happened with the Leah Thomas situation is all the girls on the swim team who were uncomfortable had to go to counseling. So Leah did not have to go to counseling. The girls who were uncomfortable with it had to go to counseling.
And Leah had no problem running around exposing his junk in front of everybody.
Yeah.
Right. That was a complaint.
Yeah. And so the problem, he was fine with it, but if you're not fine with it, you need to have counseling.
Okay. Very interesting.
So we're getting ready to make a fundamental shift in the understanding of the person. And the point that I was trying to make by the brief, if you want to talk about it now,
but first you haven't explained what the claim was in the individual plaintiff's complaint that the government wants to intervene into. I'm not familiar. It wasn't in your motion, the actual claims.
Yeah. No, the claim is that, and it's really convoluted thinking. You have to put on your thinking cap and then let the wires run a little loose. But the thinking is,
we live in Hawaii, David. We're used to that. That's how we have to deal with legislation here.
Okay, so the idea is we're all assigned to sex at birth. Okay, so that sets the stage.
By the doctor or by nature?
By the doctor.
Okay.
Or whoever fills out the state form. You know, it might be midwife or whoever it is, but you'll put, to the extent that you even put down a sex, that's your sex assigned at birth. Now, what they're saying is the discrimination is that David Fowler's born, his parents put down male, okay, and David is comfortable with his sex assigned at birth. But Eva's not comfortable with hers assigned at birth, and at age 25, she wants to be known as Ed. So you're treating people differently who all have sexes assigned at birth, and then because I'm comfortable with my
assignment
sex assigned at birth, and Eva's not, we're now discriminating between people based on sex.
Well, not only that, David, but you called my friend Eva a horse.
Well, no, I should have said something like
Mr. Ed. I watch that show all the time.
I should have said Edwin. I'm sorry. Yeah. You know, we're old enough to remember.
That's right.
That's
Absolutely. Look it up. For those young people watching, look it up on YouTube.
So they sued to have the law held unconstitutional because of the person's feelings? Like the law was interrupting their good feelings?
About themselves. They couldn't get the treatment they needed to be who they are. And all of us are only now subjective realities.
So I want to challenge the Internal Revenue Service statutes because it makes me feel very uncomfortable.
Well, you know, the interesting thing about this and is that they're talking about sex assigned at birth, and then they're saying, so there's discrimination on the basis of sex, and they pull in the cases of the United States Supreme Court where the court says, well, now, if you start discriminating on the basis of sex, take the case years ago about Virginia military, you know, that only allowed males, right? So they said, well, wait a minute, that's sex discrimination. These people over here have certain genetics and body parts, and they're not allowed to go to VMI. And so they said, you can't discriminate against them. And yes, we do recognize there are real differences between these two human beings, and you may have to adjust your dorm rooms and some other things, but you cannot withhold a military type education from women. Now, okay, good, bad, whatever it is. But the Supreme Court applies a higher standard of review. They make the state jump extra hoops, let's just put it in a vernacular way, to prove their law is valid. Well, the problem is the transgenders are wanting to use cases where there is an objective embodied truth to get a higher standard of review to decide a claim in which they deny sex.
Hmm.
So they can't have their cake and eat it. Either sex is real and you get heightened review and your view of sex is phony, it's made up subjective, or you don't get to use these cases for heightened review because they're predicated on the assumption that bodies are real things that communicate real things, and there are real differences between men and women. And you can't use those cases predicated on objective biological realities between male and female to then turn around and say there are no biological realities. You can't not have your cake and eat it too. You can't deny their sex and then claim, but this is sex discrimination.
So, and that's part of the argument that was in your memo.
Yeah, that was one of the arguments, right? Is that if you want this heightened review, then you have to buy into the idea that there's objective sex differences, but you're denying objective sex differences.
So what do you go ahead, David? I'm sorry.
That's one of the arguments, you know.
So what do you think is going to happen moving forward now with all these cases that are happening in all these different states, and you know what you're feeling is coming back, especially from the Department of Justice, and how maybe the Supreme Court is going to weigh in on this? What do you think is going to happen with all these cases?
Well, I don't know. I read, boy, you know, we really have lost our minds, and I don't say that pejoratively.
Yeah.
I say it in the sense that the scripture says the person who turns away from God eventually becomes futile in all their thinking, and they think they're wise when they're really fools. Okay. And the concern that I have with what we've been doing, and Eva, you may know I've been expressing this for the last 2 years among our colleagues.
Mm-hmm.
The other side wants to say the frame of reference, the standard we use to make these legal determinations, is what is the state of medical science today? Well, medical science says that we have these subjective things, and yes, we do have subjective aspects of our personality, right? I mean, we get it. I know I am more than my body, right? I'm not just a clump of cells infused with energy, no matter what Richard Dawkins and all those evolutionists would tell me. There's something real about who David Fowler is. He has real thoughts and real emotions and a real personality, and it's different from Eva and Jim, even Edwin and Ed, the horse. So they're saying, so the medical science tells us that this is helpful for children. Now we come in and say, oh, but we have other doctors, and they say this is not helpful for children. We've essentially put judges in the place of being legislators to weigh the medical testimony and decide what they think is the good and right policy. They're not acting on the basis of law. They're acting on the basis of making policy decisions based on the relative weight of the evidence from the medical community. Now, here's the problem with that. If you were going to try to win today on the grounds that medical science says there are just too many complications with these surgeries, look at these people who have continuing problems, so on and so forth. Well, Hawaii, California, other states, they're going to keep working on that science because their state's going to say that's fine. 5 years from now, 10 years from now, they say, well, shoot, we can create fake organs, and we can simulate orgasms, and we can do all kinds of things, and you don't even have to lactate anymore, and blah, 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 blah. And now what's our argument for why we shouldn't do this? You see, what we've done is what Proverbs warns us not to do. Do not argue with a fool according to his folly, lest you become like him.
Mm-hmm. Mm-hmm.
So we're accepting that there is no law pertaining to the objective truth about what human beings are, and we're agreeing that what we are as human beings is determined by people in white coats in laboratories.
Mm.
And for a Christian, that is damnable. But that's what we argue. We argue right along with the fool, and we say our medical testimony is better than yours. And you know what? So far, we're losing.
But you know what? If an attorney argued in court on behalf of the client's testimony that the client was created by the creator of all, including the universe and every person in this room, and they are created man or woman in the image and likeness of the creator, that's not a legal argument. It's a truth statement, but it's not a legal argument. How would you switch that around?
Sure. So what I actually do is I use the common law and I avoid the theology. Now, anybody that knows the common law would know that the English common law that we brought to our shores and we adopted, as Joseph Story said and many said at the time of our founding, we adopted it to the full extent that it made sense under our environment. Okay. And so the common law, if we won't be straight up about it, began in the English companies with Lord Alfred and his Doom Book, which is the English word that at the time meant judgment, that began with the recitation of the Ten Commandments.
Can I interrupt you real quick? What we're going to have to do is continue this online for the longer story, because I want to hear it. We're running out of time.
Yeah, so we've got only a couple more minutes left for this interview.
Well, let me make this very short then.
Well,
but we want the long version.
So yeah, well, what we're going to do is,
because we can continue it on YouTube for longer.
Yeah. So what we'll do is we'll just maybe for another minute or so finish up, and then we'll end it for the radio
for the slot. Right.
Yeah. But for the rest of you that are watching on YouTube, we'll just continue the conversation. And those listening on the radio, if you want to hear more, then go to YouTube and look for Hawaii Family Forum and look for this interview with David Fowler, because we're going to continue the discussion. So let's go for about another minute or so just to end up. And so go ahead, David. Give us a 1-minute teaser.
Okay, the 1-minute teaser is that the common law that we adopted in the United States said that every person has a fundamental right to the protection of his body, and you can't injure another person's body. So as a lawyer, Jim knows that you don't have to have a statute to create a right to sue when somebody punches you in the face or cuts off an important part of your body. So the argument is, well, the government has a duty to protect people's bodies. We provide courts for them to do that. And when somebody takes a healthy body and injures it, they have damaged that person, and the law is obligated to give them a remedy for the damage to their body. So we're avoiding the theology, using the common law, and saying, I don't care what your science is. Was the boy's scrotum healthy? Yes. Was it developing normally? Yes. Good. Then to remove it is an injury. End of discussion.
All right.
Let's get back into that in a minute.
So for those of you that are listening on the radio, like I said, go to Hawaii Family Forum. Go to YouTube and look for Hawaii Family Forum so you can hear the rest of this interview. But for those of you that are watching on YouTube, then stay tuned, because we're going to continue the conversation. So don't forget to like, share, subscribe, hit that notification button so you'll know every time we upload a new video, and share this with your friends so that we can talk about it more. And we'll see you all next week. Mahalo, everybody.
So to continue on, I can hear this Jonathan Scrimetti say, but I'm a girl with a scrotum. It might have been healthy on a boy, but it's not healthy on a girl because we're not supposed to have them.
And I just shopped at Target, and I was able to find a bathing suit that fits me properly. So go ahead and argue to that, friend. I
think what you're saying is Jim was able to find a female swimsuit that fit him properly. I think that's the point.
Well, I wasn't the one. I don't actually ever go to Target because I don't even know if we have them here.
No, we do. We have Target, yes.
Oh, okay.
We have many of them. Okay.
So anyway, here's where the genesis of this comes. And I've been blessed to work with some really brilliant lawyers. And I will call them lawyers rather than litigators. Litigators tend to say, what do I need to do to win a case? A lawyer practices law. Law is the idea that there are objective realities that judges confront, that they have to address and deal with. So as I was beginning to explain, the common law has a long, long history, but in the part of the country of Europe that we're most interested in with England, Lord Alfred, I think it's around 900 establish a doom book. And what he did was he began with the 10 Commandments, and then he developed from the Justinian codes and canon law and all kinds of other things that he developed. He developed this doom book of maxims and principles that, and Jim might know that he who wants a remedy, for instance, has to have clean hands. You can't, kill your wife and then claim the insurance benefits from her death type thing. So those things were developed, and they continued to be developed and worked out over the centuries. And eventually they culminated in a book called Blackstone's Commentaries on the Law of England that took advantage of Bracton and Grotius and Coke and Matthew Hale, all these great English jurists that were developing the common law over the time. And he established these commentaries on the law of England. And England does not have a written constitution. It's an unwritten constitution. It's based on this common law, the idea that law exists independent of the judge or the legislature. Now, that's a very Christian idea. The law against murder doesn't exist because a judge held somebody guilty of murder. Murder doesn't exist because the legislature passed a statute. Murder is malum in se, they would have said. It is in its own self wrong. And passing laws doesn't make it more wrong. So that's the concept of the common law as it was carried into our country. And the Supreme Court recognized and used it. And in fact, Joseph Story, who was probably the greatest jurist of the early years of our country, even over Marshall. Justice Marshall gets a lot of credit, but he actually took like a 6-week class in judicial readings, and Story actually really studied the law. So he was the brains behind Marshall. And he said, look, our whole system of law rests on the common law. The idea that there is a law that is outside of us, that we did not make, that we use reason to discover, we use scripture to confirm what our reason is telling us. And so you can't go into a restaurant, eat the food, and then dash. No, we think that's stealing. Not because we said it's stealing, but because stealing's wrong, and that's really what you did.
Do we Christians call that moral law?
We would call that moral law, but it was applied to certain situations. So I wrote a book called Recovering the Constitution Using the Ninth Amendment or something like that. I don't remember, but I said the common law would have developed that a guy goes into a restaurant. Now, this was an example I used, and he sees it's very expensive. So he orders a bowl of lobster bisque. That's all he can afford. And they bring him a lobster dinner. He refuses to pay. And the restaurant sues him because he ordered a lobster dinner. We fixed it and we brought it out to you. And the judge said, well, you didn't give him what he ordered. He doesn't have to pay for it. So the next guy says, well, that's a good deal. I'm going to go in and order lobster bisque and see if they'll bring me a lobster dinner.
Can I ask a question about the first guy? Did he eat the lobster dinner?
No.
Okay.
That's why he said, I didn't order it, and he leaves. So the next guy comes in and says, well, based on that precedent where Jim orders lobster bisque, gets a lobster dinner delivered, and he didn't have to pay for it. And I didn't eat it. I'm going to go in, do the same thing.
But I'm going to eat it.
For me, a lobster dinner, I'm going to eat it. So he says, Your Honor, there's precedent here. I ordered lobster bisque. They brought me a lobster dinner. And just like Jim, I don't have to pay for it. And the judge said, yeah, but in this case, you ate it. And you can't eat it and not pay for it. Ah, so that's different. Now, if the judge had said, you're right, it's just like the Jim case. You ordered lobster bisque. They brought it, and you don't have to pay, even though you ate the lobster dinner. Another judge would have come along when it's Eva, and he said, I think they were wrong in that second case. That was not the law. He should have had to have paid for that. Eva, I'm sorry, you're going to have to pay for your lobster dinner that you ate.
And the lawyer's fees now for representing you.
Truth be told, you don't eat lobster.
Well, that's true. But I mean, in this case, I would have to pay the lawyer's fees, and I would have lost.
Mahi. Let's call it mahi.
Okay, there you go.
So anyway, that was the common law. Now, with evolution and ultimately Darwin Justice Oliver Wendell Holmes in the late 1800s and early 1900s said, no, there isn't any law that transcends us, that's outside of us. There can't be. There's no God, right? So the only law that exists is what the state says the law is. Now, that's when we moved to a completely new understanding of the cosmos and law. Now, all those cases are still out there with the common law saying that every person, this is what Blackstone said, every person has a right to personal security, to liberty, moving about, locomotion, and to property. Now, the word personal security is an unfamiliar one to us, but they spelled it out. They said personal security is the right to your life, your limbs, your body, your health, and your reputation. When any of those things are damaged or ruined, your person is damaged and injured. Okay? And if you have to get a license and a permit to just go over to your neighbor's house, well, that's a violation of liberty. That worked itself into the Fifth Amendment due process clause, where it says you cannot deny a person life, liberty, or property without due process of law, which simply means, okay, here's the restriction on liberty. If you go over and blow up your neighbor's mailbox, you have to go to prison for 30 days. But you have to have a fair trial. That's due process. So now there's a law. You know what to do. And so you can be deprived of your liberty if you blow up your neighbor's mailbox and have a fair trial and you're convicted. Okay. But otherwise, I can go over and look at my neighbor's mailbox. I can wander around the street. I can admire my neighbor's mailbox. I can go buy a mailbox just like my neighbor's. See all those things. So that was the way it was understood. Then Oliver Wendell Holmes changed it. And for the last 100 years, we have forgotten what we used to know. Now, that's why this argument has been so hard for me to convince people to pay attention to, because it's like, David, you're talking about, I don't understand. That's not what common law is. And it's like, no, that really is what it is. Oliver Wendell Holmes and the godless perverted it and said, only man creates law.
We're seeing some of this play out right now. You know, when you look at what's happening in New York, right, and some of the laws that they're doing, where now somebody can go in and rob a store, right? And then, but because it was bread, right, or food, you can't prosecute them. I mean, so what you're saying, it's, even though I'm a non-lawyer, I'm kind of seeing where you're going with this.
Yeah. So we would say, no, there's a law against stealing. I don't have to pass a law about stealing. Stealing's wrong, period. Everybody knew that, right? I passed a statute to make it clear, you know, to define its terms or whatever it is. But anyway, I'm getting a little too far off the rabbit trail. So what happened last June in a very, very important case that nobody paid attention to? It was called New York Rifle and Pistol Club versus Bruin.
Oh, Jim knows that one very well.
Yeah. It's a Second Amendment case. And it, except for the fact that we're all pro-life, it was constitutionally more significant and substantive than the Dobbs case, in my opinion. Now, I like the Dobbs result that, you know, at least overturned Roe versus Wade. But Justice Thomas wrote the opinion in Bruin, and 5 justices signed it. Now, that's important, because now you have 6 justices ascribing to what Thomas wrote. And what he wrote is the words of the Constitution, or the Constitution, is to be interpreted according to its text. Okay, it says persons, right? And its history. And then he went on to explain, here is how we've looked at this issue of guns and carrying and militia and all that, all the way from the Magna Carta in 1215 up to 1789, we adopted the Constitution, and in 1868, when we adopted the 14th Amendment, and it would have always allowed this kind of weapon to be carried without having to get government permission. So New York, your law is wrong. Okay. Now, Dobbs is important because they said, okay, you want to argue there's liberty, Okay, that's true. And you want to argue that a person who's a woman has liberty, and you argue that that liberty includes killing her baby. Well, let's look at the text and history. Well, all the way up from, and they again went from like Bracton in the 1300s up to the adoption of the 14th Amendment in 1868, and they said abortion was always a crime. So they could have never intended the word liberty to encompass a right to commit a crime. Why would they have constitutionalized a crime? That's nuts. So Roe is reversed. Now, what we never argued, except Eva, I think you joined me in the argument that we filed with the United States Supreme Court in Dobbs.
Yep.
And Robert George and John Finnis at Notre Dame, who are friends of Barrett and taught Barrett, they filed a brief that both made the argument. We know what a person is. According to the common law, a person is one whose life comes from God and not created by statutes or has imputed existence. And we know at the common law, the child in ventris mir, the child in the womb, is a person for all legal purposes relative to what an unborn could be. But we've never argued that for 48 years. We've never said, hey, if we're going to apply the 14th Amendment, let's define what a person is. It's never crossed our mind because we're such positivists. We just look at whatever the Supreme Court said last month and we don't say, wait a minute, is that what they meant? In 1789, when they used the word person, that it was subjective, divorced from your body, understanding of human beings? Heck no. Is that what they meant in 1868 when they adopted the 14th Amendment and they used the same phrase as in the 5th Amendment adopted in 1789? Are you nuts?
You should probably remind people what the 14th Amendment is because you've quoted it twice. And if I'm not mistaken, didn't you write a book on the 14th Amendment?
Well, actually, I wrote it on the 9th Amendment, using the 9th Amendment to recover the Constitution. But it intersects the 14th, and we don't have time to get into that. But yeah, I did talk about the 14th. So the 14th Amendment, and let me just, do you mind if I back up? I mean, I don't know how long we got to go.
We might as well now make this, if you go for a few more minutes, we can make this our third show. So we'll just have people.
I'll be very brief about this. I'll be very brief.
Continue.
Most people don't know this, but if you will Google it, you Google this word, preamble to the Bill of Rights. Most people don't know there's a preamble to the Bill of Rights. They know there's a preamble to the Constitution. We, the people, in the United States, blah, blah, blah.
You're speaking Jim's language. He's getting excited.
So there's a preamble to the Bill of Rights explaining why they did it, and it was adopted by Congress. It wasn't wiped out. It wasn't like preambles of bills that get wiped out. They said, here's why we're doing this. We are adopting these things to make clear the federal government does not have any authority in any of these areas. This is all left to the states. So the First Amendment, Second Amendment, Third, Fourth, Fifth, blah, blah. Then they get to the 9th Amendment and they say, and this enumeration of rights, 1 through 8, that isn't everything. There are other rights that people have that have been retained by the people, and the 10th Amendment says, and the states and the people have the right to protect them. So the Bill of Rights was not granting anybody any rights. It was saying these are the rights the federal government doesn't have, that it can't do. So you can't construe the right to establish postal roads by taking people's property without due process of law. You can't do that. You can't establish a military under the clause to establish standing armies and deprive people of their guns under the Second Amendment.
You cannot establish a government religion.
That's right. Now, so the 14th Amendment came along and did alter that a little bit. And they said, well, here's the deal. So now I'm getting to your question. No state shall have any law which shall deny any person the right to life, liberty, or property without due process of law, or deny the equal protection of the laws. So every person has a right not to be deprived of life, liberty, and property. That goes back to Blackstone. goes all the way back to Bracton and those guys hundreds of years ago without due process of law, nor can you deny any person equal protection of the law. So the question becomes, okay, who's a person? Now, until transgender came along, we didn't have any confusion about what persons were.
Right.
Persons were human beings, and they had sexed bodies, male and female. And the court said you can't, in certain areas, you can't discriminate against men and women, between men and women. They interpreted that as equal protection of the law, and that's another question. But in any event, now the Department of Justice is saying, we think persons should be defined according to their gender identity. And our side is just going along with this crazy theory of saying, well, you know, you shouldn't be cutting off body parts because you're confused about your gender. What we filed a brief was to say, no, you can't even define the person that way.
Mm. You know, you bring up a really good point, because this really does tie into all of the issues we've been talking about recently. This whole confusion with the gender ID stuff. People think that, even Christians, right? If I just ignore it, or I just accept somebody because this is how they feel, I'm being loving, I'm just doing it. But even if you stay silent, there's all this working that's happening that's going to affect us through law. And ultimately, all of that is going to hit us in our businesses and in our churches and all of that. So I think in these last few minutes, we should talk a little bit about that. Jim, you've been quiet, so I know you have some thoughts.
Well, I got a few. One is, I wanted to ask, did you run into the Hawaii Supreme Court 1996 case called Bear v. Lewin? It was the first same-sex marriage case.
I'm aware of it.
Well, you might want to take a look at that. A friend of mine, Fritz Rolfing, wrote an amicus brief at that time arguing that same-sex marriage, number one, discriminates on the basis of sex, because women marrying women means a man's not marrying a woman, but it also doesn't discriminate on the basis of sex because both sexes are treated the same. They can each marry the alternative, and neither can marry the same. Right. That argument didn't survive because our state Supreme Court ruled that equal protection clause required same-sex marriage at that time, which is why we did the constitutional amendment. But my bigger point that I think I would like to make is, this is really, this whole transgender thing to me, and I didn't make this up, read it in a bunch of places, is a affront to the Creator and his creation. And that's what the battle really is. So caring for and grieving for people who cannot accept their created self is something I think is critical for people in the church.
Right. It really is. And in fact, I have a new book coming out called Transgenderism, Ancient Issues That the Ancient of Days Answers. And really, it's sort of a theology book, although the last 3 chapters deal with how do we address this legally, okay? And I've been talking some about that today. Don't argue with the fool according to his folly. Accept the proposition that, okay, you have this disconnect, but I want to ask you this. Is your scrotum healthy? Is it functioning properly? Right. Would it be wrong for me to punch you in the nose and break it where you can never breathe again? Oh, absolutely. Great. So cutting off your scrotum is the same thing. I'm going to let you throw out your premise, but then I'm not going to argue with you. This is Proverbs 26, 4 and 5. Don't argue with a fool according to his folly, which is exactly what every Christian organization is doing. We're arguing about the medical science.
Right.
And you are letting him think he's smart in his own eyes. He turns right around in the next verse and says, answer a fool according to his folly, lest he think he's wise in his own eyes. So we can either become like the fool by accepting their premises and arguing them, or we can say, okay, if that's your argument, let me help you understand where you're not wise. So we have to learn how to engage these issues. But the point of all of this is that there have been issues throughout history, going back to the 4th and 5th centuries among the Greeks, about what's the nature of reality. Is Is there a permanent essence or nature to things? Or are things always changing? You may have heard the expression, it came from Heraclitus. You never step into the same river twice.
Mm-hmm.
Everything's always changing, which is true. Now, you and I would say that there are real natures and essences to things, which is why you'll always, Eva, be a woman. Now, you will change, you'll get older, you won't be able to have children, right? And so on and so forth at some point. And you know, given that you're not quite 30, you better get started here, Eva. But anyway, but see, the Christian
She's
would
already
say,
got 10 kids.
I have 12 kids. No.
We have a basis for understanding that there's permanence, but yet there's change because our God is one in three. There is differentiation, but yet there's unity. The Trinity is a great mystery, but man and woman are revealing from the very first pages of Scripture this mystery that's ultimately, Paul says, this is the great mystery of the ages, the Father and the Son. And then there was this question of, well, where is the essence located? And is it in God or is it in the thing? Well, what are the homosexuals saying? They're saying everything's in a state of flux and it's located in the thing. So I can flux and change, and whatever I am is what I am. And you can be whatever you are. And you can look just like me. This is why Ketanji Jackson Brown couldn't say what a woman was. She knew what she was. And yes, you look a lot like me, but I can't say what you are because there's no true nature to anything. And everything's particularized. There's nothing that's real. It's all nominal. And then you get into this question of unity and diversity. And so anyway, we're just going to, as Solomon said, there is nothing new under the sun. We just need to know that we're facing a different expression of the same things that have gone on throughout history, and the same thing that changed a pagan culture of Rome was the Christ, the understanding of the triune God and who he was and as the creator. And over time, it changed the world.
And that is such a good place to end, because every issue we talk about for our viewers and listeners, you know that we always end on hope, because we're Christians. We are a hopeful people. We reach the promise of God that he's created all men and women in his image and likeness. And as Christians, we believe that God doesn't make any mistakes. And I think that we should learn to rejoice in who we are and how we've been created, and be able to accept ourselves for the precious gift that each of us are to a heavenly Father that loves them. So Amen. We thank you, David, for joining us today for this discussion. And for those of you watching and listening, make sure you like, subscribe, share this video, hit the notification button so you know every time we upload a new video. And Jim, I will see you next week. And David, we'll have you back, because I found this conversation very fascinating today.
All right. Blessings to y'all both.
Bye. Same to you. Aloha.
Take it easy.
Aloha.